All right. Well, hello, everybody. And we are back. We are going to discuss in this video the Revocable Living Trust. So, just by way of kind of gathering where we are at the moment, remember in the plan that you are getting, which internally in our office, we call it an Asset Protection 2 trust. And then number 2 signifies how many trusts. There are two, right? There is a revocable and an irrevocable, and we'll discuss the irrevocable in the next video. However, I do want to kind of do a spoiler alert here. You will notice that these two trusts are very similar. There will be provisions in this one in regards to the lifetime trust that essentially say that you can, as the grantor and trustee, revoke, modify, amend, nullify, do whatever you want. And in the asset protection trust, it will say that you can give the principal or income of the assets to anyone you want, except for, yes, you're right, yourself and your spouse if you're married. So you'll see a ton of similarities. You'll see a ton of repeat between these two trusts. So this one is probably just less significant in the sense that we're having everything from this trust pour over into the asset protection trust. So we'll certainly talk about the dispositive provisions in this trust because we do have them listed, again, just in case. But certainly probably not going to be using the provisions here much at all, although they will mirror the ones that are in the irrevocable trust, just for clarity and a fallback to a fallback to a fallback. So certainly nothing I'm concerned about, but just as a way to be completely transparent and clear and clean and making sure that there is all kinds of fallbacks. So here is the revocable trust cover page. Of course, the dates will be filled in on the day that you're going to sign. And we have a table of contents. Similar to what I mentioned in the will video, table of contents is simply where to find something. These provisions are not dispositive, meaning they don't actually tell you what the actual document does or says, although you can certainly pick out probably what most of it does based upon it. But the actual document itself is where you're going to find the dispositive provisions and what's actually occurring. So if there's a conflict for some reason between the table of contents and the section in the document, the section in the document is going to prevail. This is merely just where to find it. And you will see that, we got the page numbers 6-1, 7-1, and so on. So I'll scroll through this because you're going to actually see all of this. So spending a lot of time walking through it doesn't make a lot of sense. The trust itself, of course, Mark and Sarah are the grantors. They are the people creating it, and the trustees, the people controlling it, which will also be the same in the irrevocable trust when we get there. Of course, remember, the purpose of the revocable trust is for the assets that we are leaving out of the asset protection trust because we want direct access to it. We want to be able to do whatever we want with it. We want to be able to have fun money. We want to be able to go around the trip world money, whatever you want. We want that stuff. And we also need a place for your income, your Social Security, your pension, your wages, your all of that to go into. So we use the revocable trust so that any assets that are left in your name alone avoid probate. Purpose: to revoke to do probate avoidance, avoid probate administration, manage the assets, especially during incompetency, incapacity, and also at death. Ensure that all assets are incomplete gifts for federal estate tax purposes. Not really important, but the truth is any assets that you're putting into this trust are still in your Social Security number and you are still in control. So there is no completed gift being given, which we don't want there to be. But I just wanted to point that out. And also in regards to the 401, we have all the language in here for this to be qualified as a designated beneficiary, which they call under the Secure Act a qualified designated beneficiary, but we'll get to that in a little bit. The identification of the trust is Mark and Sarah Smith, trustees of the Smith Revocable Trust, and we can transfer property into this trust. Now, the truth is, for 99.9% of people, your real estate is going to be in the Irrevocable Asset Protection Trust. No reason not to. Easiest asset to protect. Certainly, we would have to have had a special conversation to not put it into the Asset Protection Trust. I left it here in case someone does decide to do that, but the truth is you probably won't be using this trust for the real estate, so it really doesn't matter. But all it says is that there won't be any transfer tax. You'll remember in the blueprint meeting, I said that we're going to provide for all lineal descendants to avoid any transfer tax implications and complications. So we're just simply providing that here as well. The trust is composed of any assets that have the title. Sarah Smith and her husband, right? Trustees of the Smith Revocable Trust. I believe it was Sarah and Mark, and that's what it's composed of. You can always add to the trust later. That is the subsequent additions. No new tax ID number is the fact that it's in your SOCH, and if you're married, it's in one of your SOCHs, and then we'll have the IRREV trust in the other. We're still going to be filing our taxes on our own 1040s, so nothing there. Third parties have a right to rely on the affidavit. As I stated in the affidavit video, the truth is a lot of people don't want to accept it because they don't trust anybody and they want to make sure that it's correct and they want to see the trust. So to the extent that, you know, it is accepted, they can rely on it and you're able to use it. But as I said, most people are going to require to see the full trust. Scrivener's errors. This part is just saying, you know, allow me to make additions, modifications, changes. Please don't punish me because my lawyer is an idiot. Clearly much more eloquently than that, but that is what the bottom line is. We just identify your children here. Just again, to be clear, just verify who the husband is and how many children we have. We are going to talk about these trusts because these are separate headings coming up. But during life, it's a revocable trust. And then there's a residuary trust. There's a separate share trust for the kids. And there's who the beneficiaries are. So let's just take a look at that. During life, remember, this is revocable. So you can amend it, you can modify it. It does not provide asset protection though, right? So this section is saying I have the ability to do anything I want, essentially. And of course, the income tax consequences are the same as if the trust wasn't there. So people get hung up on the language. It's in your SOCH, it's on your 1040, no difference in tax implications. So when people are asking questions about either this trust or the IRREV trust, my response always is the same. Well, tell me how it would be if there wasn't a trust. And then the client answers and I say, great, that's exactly how it is then. So don't get too concerned about cap gains and that kind of trust. That's all how it is with or without the trust. You're, of course, able to use the trust, sell the trust, assets, do whatever you want. You can withdraw principal. If you were to become incapacitated, then, of course, it would go on to the next trustees. Now, the one thing about this trust and the irrevocable trust that we talk about is the fact that you're able to be the trustee, which is great. That's wonderful. The downside is, what if you're not able to do it? What if you don't have the capacity to understand the implications of your decisions? What if you think you're George Washington and you think your job is to give assets to everybody who is homeless or anyone on the street corner? So clearly not acting in the best interest of the trust. We have inputted in these documents something called a disability panel. In this case, it's the spouse and the two, you know, we'll call them well children, the child without the disability. We don't want to do, in this case, Jeff is not able to be a trustee because he doesn't have the ability. In some cases, they do. An individual with a disability can still potentially be a disability panel member, but that is not how I drafted it. I did it as if Jeff could not. Your case will be different. That would have been a question that we had on the blueprint that we discussed. So in this specific case, it's saying the spouse and the two children, and they have to agree unanimously. And we have that both for Mark and Sarah. It's just the thing to think about trusts is that we want all of our negotiation and everything to occur at the conference room table. Kind of looked up to the left there. I don't know if you saw my eyes because I'm looking at my conference room table. We want those kind of decisions to be made in-house, not in a courtroom, having to hire lawyers and have a judge preside over it. So essentially, we can remove the trustee. And of course, if it's Mark, for example, then it would just be Sarah remaining. If Sarah can't act, then of course it would go to Jeff and not Jeff. I apologize, Dan and Reese. So the two remaining children who are able to act would then be stepping in the shoes as the trustee. In a revocable trust, the trustee does have the ability to do asset protection planning. And when the grantors die, then we are going to go ahead and administer the trust. Administration of a trust is very simple. Pay our debts, our expenses, and our claims, as well as the taxes. So you will see this provision here. This is also going to mirror the irrevocable trust. We need to get the money to the individuals that are named. And of course, in order to do that, we simply just have to make sure all that stuff is taken care of and the money goes to them. We're lawyers, right? So we have to make sure that everything is done correctly and that it specifically states it in the document. So this section goes into detail about how to redeem treasury bonds, how to coordinate with the executors, how to make sure if there is any assets or if there are any assets that are in the will, that those two are also taken care of in connection. It's just providing the language that allows for that. What do we do if we have exempt property? What do we do if there's retirement accounts passing under this trust? So I will say this, the retirement accounts will probably be passing under the irrevocable trust. Again, we're kind of having everything directed there and having that trust be the dispositive. I left it here just in case anyone makes a mistake and puts it into this trust. This is all verbatim out of the IRS code. So the truth is, it's very detailed, it's very specific, but it is also just right out of the code. So while, you certainly want to breeze through it, it's not something that you're going to spend a ton of time on. When you see determination dates, those are just things that are put into place by the law to determine whether an asset is a retirement account, and also the time period at which we have to make decisions. So that is also in here. The trustee's authority to make tax elections. Of course, we want to keep the tax consequence down as much as possible. And under the Secure Act, we want to maximize, the effort that we can. I'll talk a lot more in the irrevocable trust about retirement accounts simply because I don't anticipate that any will be going through this trust. I'm more just trying to get through the document, instructions regarding trust settlement, how to get them over to the individuals that we have named, that if we have any death tax returns, we have to get those done. Certainly there will be inheritance tax returns because you are in control of the assets. So there will be inheritance taxable. But as I stated in the blueprint and in the 3 secrets, that's a good thing. Your children then get a step up in basis and then avoid the capital gains tax, paying the funeral expenses, distributing tangible property to the spouse and then the kids. Everything's going to pour over into the irrevocable trust. So really, this is kind of the whole kit and caboodle right here. Pretty much says everything pours over into that trust. In case there are any retirement assets for Mark, I do have the language in here to hold it for Sarah and Sarah for Mark. And that will allow us to use what is called a spousal only retirement trust. If you're not married, this will not be here. And if you're not married, the next section will not be here either. But I do want to just walk through it. We'll do it the same thing on the IRREV trust video as well. Termination of the administration trust occurs when all of the taxes, claims, expenses are paid, and then also that we distribute the money. Now, this is the spousal only retirement trust in regards to married couples. If we're going to have a retirement account for the spouse and we're able to essentially get the best asset protection that's allowed under the Secure Act and also um, stretch it out as long as possible, the Secure Act tells us exactly what to do and how to do it. This language is built in here, again, right out of the code to tell us how to do that. And then after the death of the surviving grantor, of course, it's going to go to the residuary beneficiaries, the children in this case. Under Article 5, this is a section that I debated removing, again, because I'm having everything go over into the asset protection trust, but we decided to leave it as is. I don't think that education is a bad thing. I don't think repeating it twice and also having a fallback is never a bad thing either. So this is saying it goes to our 3 children. And if there are any retirement assets, how are we going to do that? There's language here about conduit versus accumulation trusts. Conduit trusts essentially allow us to comply with the Secure Act, which is a fairly new thing since 2019. Every year when we have to take a distribution, we must take it out of the trust. However, we can get it asset protected if we needed it, and we'll just pay higher trust tax consequences. That is what we call as a game time decision. We don't make that decision until you pass away and until we know the situation of your spouse or of your children. And then, of course, the language is built in here so that we can get the most asset protection we're allowed, as well as at the best possible tax consequences. An accumulation trust is where we keep the assets in the trust because we need asset protection. It is allowed for special needs trust and doesn't trigger any negative taxes. We're allowed to stretch out over the life expectancy of the individual with a disability. If we do something like that for people who are not disabled and in a special needs trust, then it could trigger some higher taxes. However, I'd rather pay higher taxes than lose the entire asset in case the spouse or a family member is in a long-term care situation. So we'll play that one by ear. We'll make that decision as a game time decision at the end. There's also another exemption on the Secure Act for beneficiaries not more than 10 years. If they are less than 10 years away from the grantor, then there's a way to kind of not be held by the 10-year standard. This is kind of explaining that as well. And again, we're talking about conduit distributions versus accumulation. We'll do what is best for the family at that time. What if we have any special needs beneficiaries? Again, we want to meet the requirements and make sure that we do that correctly. We will definitely spend a little more time on the EREV trust. If we have Dan receiving a share, his is going to be placed into what we call as a separate share trust. You will see later that he'll have the ability to be in complete control of the money upon the death of the grantor. I believe it says that he can do it at 25, which he's older than 25. So he has it immediately. Reese, who is having some spendthrift issues and just some, drug addictions, we're holding off for him to be in complete control until he's 65. And Jeff, who is a special needs son, it will never have the right to fire and be in complete control because that would violate the special needs trust provisions. So each of them will be different, which I'll highlight later. Currently, this is just saying that the money goes to Dan in a separate share trust. And when Dan dies, his share goes to his children per Sturpes. So you'll see that under there, under C, which is right here in the document. Then we have Jeff's share. So Jeff's going to be a little different. Now you're going to see the special needs trust language. So it's going to talk about Lang and its progeny, which just basically means the Lang decision and then any subsequent decision that came after Lang, which is kind of the seminal case in Pennsylvania in regards to special needs. It says that the money can be distributed to Jeff for anything other than food and shelter. The money is intended to supplement, not supplant the benefits. So you'll see that language in here as well. We describe what supplemental needs means and how we want to enhance a person's life. And if you say it the opposite way, you could pay out for anything other than food and shelter. I know that at times when you read the document and when we teach it in special needs trust workshops, we kind of focus on, vacation, vocation, horse rehab, horse therapy, and people only hear those words, but it's anything other than food and shelter. And that is because for SSI purposes, there are some deeming rules where they deem if you distribute something for food and shelter, it's actually income, which will then reduce the benefit that's being received in subsequent months. Uh, Sometimes it's better to do that and reduce the benefit than it is to not get the money, but the trustee will make those decisions. They do have the authority to consult with other professionals. We want to make sure any taxes that are owed are also getting paid. And how do we distribute those assets, qualified and non-qualified? When making decisions, the trustee has a right to consider other benefit sources and whether this distribution would disqualify him. And in some cases, we will disqualify an individual if the money or the benefit from this trust is greater than what can be given. Ultimately, that is going to be up to the trustee. Again, reviewing other potential benefit eligibility allows the trustee flexibility, and we're not going to be forced to make distributions that are not allowed or that are going to cause an issue if the trustee does not want to do so. Essentially, it's going to be up to the trustee. And this is repeating that we do have the ability to make payments, even if he's going to lose benefits. And if Jeff dies, it will go to his children per stirpe. So I believe all of the documents are going to say that. The main reason for that is because if we said a non-lineal descendant, we would trigger a 2% transfer tax when we file the deed. So if you notice that you have a non-lineal descendant in your trust that where the house is, please let the attorney know. We tried to make sure that that doesn't happen, and we will just kind of come up with another plan, when we get to that point. And then, of course, we have Reese. So Reese is going to read exactly like the trust did for Dan, and it also provides to his children an equal shares per stirpes. The only difference is that he won't have the right to fire, which will come later until he's 65. But this section reads the same. And I did 3 examples in this trust and in the EREB trust. We did a separate share trust where they have the right to fire right away. We did a special needs trust where they never have the right to fire. And we did a separate share trust where they don't get the right to fire until 65. In my mind, you never want to give money outright to an individual. So that isn't something that I've shown because I don't believe in it. Ultimately, if that is what you chose, we certainly respect it. But our opinion is have it go protected. They can always get it out if they want it. Never make that decision for them, because once it's out, they can't put it back in without waiting the look back period of 5 years and potentially having to trigger some pretty hefty tax consequences if retirement accounts are available. And I know we kind of beat that ad nauseum in the blueprint in the 3 secrets, so I won't kind of go into my diatribe here, but suffice it to say, we highly recommend it. This is another section that in this kind of plan that we're doing, we debated getting rid of or not, because we have all the money going in trust, but it's still a fallback. I still, in case we had a bunch of deaths and maybe a cousin was to inherit, the money is going to be put in a trust. I don't ever want to see a situation where somebody gets around the provisions of the document and argues that they didn't apply to them. So we're going to leave this in. It essentially says that if anyone was to inherit and they weren't specifically provided for above, that they don't get it until they're at least 30, and it still remains in a trust. I don't think that anyone ever wins arguing against these documents that it doesn't apply, because it specifically says it applies to every, but we leave it again as a fallback provision. As you can hear and see, we have a contingency for a contingency for a contingency. And then this is a standby special needs trust. So what if someone other than Jeff is disabled and receiving public benefits? We have the money going into a special needs trust for their benefit. A lot of this reads very similar to Jeff's section. The trust that we did for Jeff, this section reads very similar. Again, wanting to maximize benefits, also take advantage of any tax consequences that we can. And we're going to be able to take into consideration other benefits and potentially lose benefits if we end up receiving it, if we think that it's worth it. Again, this is another fallback to a fallback to a fallback. If everybody was to die that is named, we want it to go to the closest living relative. I don't want to take any chances on the state having any sort of right to having the asset to sheet. So we add that. Probably another one that could be removed, but again, I'd rather leave it in. There's no reason not to. Article 9, this is where we talk about the trustee of any of the trusts that are being set up. Of course, remember, during lifetime, it is me, right? And then we have in this situation, it will be Dan and then Reese. I have the ability to serve as trustee. The appointment of trustees, it's me first and my wife, Sarah, assuming that I'm Mark. And then if we can't do it, it's Dan and then Reese. For the spousal only retirement trusts, if it's for Sarah, she's going to be the trustee with Dan, and then vice versa. It would be Mark with Dan as well. On the separate share trust, this is where you're going to see the language that says that the children can act as co-trustee when they turn 25, meaning they get to manage the money on a daily basis. Now, not Jeff, because that's a special needs trust. The trustee for Jeff is going to be Dan. And then if Dan can't do it, it would be Reese. If there's ever an understated age, it's going to be the parent or guardian or the general trustees as listed. And we have all that language in here as well. If any of the trustees do not live in the United States, it can be done, but you better know what you're doing and take into consideration any possible tax consequences resulting. We don't recommend it, but it certainly can be done, and there is language in here to do so. The trustees, of course, can resign at any time, and we have the right to serve, fire, appoint, and do what we want during our lives. This is where it says that Dan has the right to kind of remove any trustees when he turns 25. Well, he's already 25, so he has the right to do it now. Reese doesn't get it until he's 65, and Jeff never gets it because that would violate the terms of the special needs trust. The trust protector, who is the law firm, which we will get to in the next section, does have the right to remove if there is cause, and it has to be pretty blatant. In 20 years, we've actually never used that right to exercise. We added it because there was some case law out there that really kind of drug a trust through the mud and depleted all the funds fighting, and ultimately it didn't need to be that way. And so we've added it. Of course, it's after any rights that you would have as the grantor and any rights that your beneficiaries would have, but it's just another ability to do it without having to go to court. And as always, there's no fee. I mean, we don't charge anything. We're just here to help to make sure that we have flexibility. That's what the advantage of trusts are, to take care of things at the conference room table and not in a courtroom. Here is the beneficiary's right to remove in regards to the spousal only retirement trust. This will not be in a single individual widower document. And remember, they have the right to remove until they are with another individual for 3 consecutive midnights. That is the remarriage protection language as well. Here we are talking about the removal of the separate share trustees, which we've discussed. If there's any vacancies, it can be appointed. The beneficiaries can appoint, as well as the trust protector, but it has to be a family member, a blood relative, CPA, attorney. They cannot be a blood relative. And it talks about all of that here. So this is all the language in regards to vacancies. A trustee can be compensated for their services. Generally speaking, family members typically don't. Corporations typically do, but it is in here to allow us to know that the grantor can serve as the trustee. Trust protector is going to be the law firm. Now, we can change that. There is certainly no requirement that it be us. It has to be somebody, and it cannot be anyone in the family in the documents. It's got to be an unrelated third party, and most people would prefer just to have the firm. In 20 years, we've never charged for this service. I did have a case where somebody wanted me to arbitrate for 8 hours, a family dispute. And I was very clear and upfront that we would have to charge for that. Ultimately, the family settled. They were fighting over $500. So it made absolutely no sense. But outside of that, it's really just a service that we offer in order to be able to have flexibility if somebody loses capacity. Where it mainly comes in is if a beneficiary loses capacity and can't speak for themselves to appoint someone else. That's really where it's used most of the time. And it's very rare. I don't think we've never removed someone for cause even or anything. I mean, we've never done that. We've only ever had to do it in a situation where somebody didn't have capacity. So that language is here. If you want, please list it as a question for the attorney. If you want to name another, like a CPA or another attorney, because we wrote the documents, it makes sense for it to be us because we understand them very well and we know what we can do and can't do. But totally your call. Of course, you have the right to remove us at any time and appoint who you want. The beneficiaries have a right to remove us as well. And any backup trustee can be named. Again, same limitations. We want it to be a professional who is not a blood relative. If there's any vacancies, again, same thing. And what powers or duties. So here's where you're going to want to read to see what powers and duties. I know that it's administrative provision. I don't have the right to change, who gets it, when they get it, how they get it. It's merely just to appoint in the need that someone can't do it themselves or lacks the capacity or there is cause to remove someone. But this all is here. So you'll want to take a look at this section. Trustee powers. So just like fiduciary with the power of attorney and also in the will, the executor, we have to list the powers that the trustee has specifically and give them the authority to sign. This section here is just paragraph after paragraph of everything they're allowed to do. Suffice it to say, anything and everything the trustee needs to do, they have the authority to do. As far as the allocations in regards to tax accounts go, we're following the Secure Act. We're doing everything that is set forth in the Secure Act to make sure we don't violate any provisions of that act. And you can purchase life insurance. It's a paragraph that's in there. People always say, well, why would we ever need to do that? The truth is we don't know. We need the authority because if it's not there, we can't do it. So I don't believe to date we've used that, but I know in situations where it was needed in other situations and it wasn't in the document. And so we added it to make sure that we don't run into that issue. And if there's a small enough amount of money, typically like 10,000, we can get rid of the trust and just, get rid of it. With the revocable trust, we probably wouldn't. That would probably be more of the asset protection trust or the trust in the future, but it is there to ensure that they have that power. Trustee's not going to have any personal liability unless they steal or unless they're grossly negligent of their duties. So not really anything to worry too much about. Retirement accounts, again, I would imagine that we're going to be running them through the IREV trust, but this will be very similar language right out of the Secure Act, defining what they are, what the eligible designated beneficiary means, which is under the Secure Act. What does it mean when a trust is a beneficiary? How we have powers of appointment, how we make sure we don't violate any of the terms of the qualified see-through trusts under the Act. This stuff is right out of the Internal Revenue Code. This is the section that if you have insomnia, I would certainly pull it out. We talked about accumulation and conduit trusts earlier today. This is also going to be here again. We're going to probably see it one more time, actually, but RMDs, this describes what that means under the Act. And then our last section is definitions, just similar to the will, where we define all the most commonly litigated words, headings, and phrases. Here we do the same thing so that people don't fight about what we intended. We intend the meaning of the word to mean the meaning of the word, unless we state otherwise. So if we state otherwise, then it means it. If we don't, then it does not. And that pretty much rounds out the the revocable trust. We will definitely go over the irrevocable trust in another video. As I stated, a lot of the provisions are very similar to the irrevocable trust. So on that video, you'll be hearing a lot of the same. The biggest difference, the revocable trust, you have a right to amend, change anything and everything. Whereas in the irrevocable trust, you can change anything except the ability to give it back to yourself directly. Everything else is pretty much the exact same. The retirement account language will be the same. The ultimate distributions will be the same as it relates to Dan, Jeff, and Reese. And we have it set up the same way in that document for ease, which will probably be the same way that we'll have it in yours to keep it consistent. Ultimately, I would like the asset protection trust to govern the provisions of the document. Purpose of the RLT, any assets that we're not putting into the trust during life, make sure we avoid probate and save on costs and make it easy for your family. We'll see you on the signing video for the asset protection trust, and hope these videos are helping. Thank you so much.